Yes, Mr. Ramlogan, can I check that you can hear us and everything is functioning correctly?
I'm hearing you loud and clear, my lord.
Very well. If you would like to make your submissions then, please.
I'm deeply obliged to the court. My lord, the issue of appointments, promotion, and disciplinary matters in the public service in Trinidad and Tobago is a very serious and important one. The public service comprises the single largest workforce in the country. More than that, it is the civil service that is the engine to implement government's policy. And it's for that reason, since the early decision of the board in Endel Thomas, it noted that the purpose for insulating the public service from the possibility of political influence and interference was one that was peculiar to a post-colonial society such as ours, with a particular political and racial mixture that gave rise to certain dynamics. And the Public Service Commission regulations, which are made under the Constitution to guide the independent exercise of power by the Public Service Commission, is meant to be a detailed and comprehensive code that will provide certainty, clarity, and predictability in these matters as it concerns the careers of public servants. The idea was to not leave too much to chance and to not provide fertile soil for arbitrariness and exercise of discretionary power out with the regulatory framework that was intended to govern the exercise of that power. And why is that so? It is because the regulatory framework contained important procedural safeguards that were there to protect against racial discrimination, political bias, and in a society that was sharply divided along ethnic and cultural lines at the grant of independence. So that this was meant to be an important bedrock in a fledgling democratic society that had peculiar and unique problems. And the regulations must be viewed against that political and historical and social context because it fulfills a very important purpose apart from the obvious rule of law issue that arises because it is part of the corpus of the laws of Trinidad and Tobago. Now, my lords, the danger is that any time one steps outside of that framework and devises a procedure out with that regulatory framework without seeking to amend those regulations, you create fertile soil for arbitrariness, unfairness, and bias. It undermines the integrity of the regulatory framework that was put in place to guard and ward against precisely that type of behavior and conduct. Now my lords, in one of the early cases, Raj Kumar versus the Public Service Commission, Lord Mackay of Clashfern had said that these regulations are not to be taken lightly because they generate legitimate expectations that are enforceable in the interests of the rule of law. And my lord, quite a few, there's been some litigation about it whenever there's arbitrary conduct on the part of the state. Now, in this case, the appellant, and my lord, it's unfortunate we have to trouble my lords with a case like this because the factual matrix, it's taxing on the brain. It's a very difficult factual matrix. But be that as it may, Mr. Pennington and I will do the best we can. My lord, Your humble appellant joined the fire service on the 1st of June, 1979, and you will see that at page 665. He unfortunately retired on the 5th of July, 2022, after some 43 years of loyal service to the government and people of Trinidad and Tobago. My lord, the organizational chart that against which one must measure the career advancement of this officer will be found at page 856. And that will be the organizational chart that we'll be focusing on. We take it from the rank of divisional fire officer upwards, because those are the ranks that we're concerned with in this case. Now, my lords, in the year 2013, it is not in dispute that the key comparator in this matter, Mr. Lane, had completed what's called the International Brigade, the IBCC course. And you will see that at page 815.
Sorry, could you repeat that reference for us?
Yes, it's page 815.
815.
And 815, and it's 2013 that Mr. Lane, you will see at paragraph 9, 4 lines down, Mr. Lane received his certificate in the Brigade Command course in 2013. And my lord, I take you next to page 950.
And
Now,
sorry, just before you move on, page 815, what is this document that you're showing us?
I beg your pardon, my lord. 1 second. Yes, my lord, this is a response to the pre-action protocol letter that was written. If it starts at page 814, I beg your pardon. And it's dated July 13th, 2020.
Yes, thank you.
And it simply recites the fact that as to when he got his completed that particular course. And I'd like to take my lords next to page 950. This is an order of merit list that was compiled for the post of Deputy Chief Fire Officer. And you will see Mr. Mervyn Lane listed at number 3. Now, my lords, we take strong issue with this document for several reasons. As you will see in due course, to be eligible to be interviewed for Deputy Chief Fire Officer, there were certain minimum prescribed requirements. Namely, you had to have satisfied the qualification requirement, but you also had to have a certain amount of experience. And these were conjunctive criteria, both of which had to be satisfied in order to meet the to be eligible to be considered and therefore interviewed. Our complaint is that Mr. Lane, who did not satisfy the experience requirement, was somehow magically allowed to be interviewed and placed on this merit list. Now, my lord, the appellant learned about this.
So can you just help us? What was the experience requirement in 2015?
It was, my lord, six years in a senior managerial position in the fire service.
Sorry, 6 years at senior managerial position.
Yes.
And what does that mean? What did that mean?
That is precisely one of the problems in this, because we have conflicting answers to that question from the respondent, which I will submit is illustrative of the very type of arbitrariness that the regulations were designed to completely avoid.
Right, but what do you say it means, if anything?
My lord, we say that it means what the High Court judge found, which is it starts at the level of assistant divisional fire officer.
Sorry, can you tell us the post again? Just missed it. Starts at the level of
assistant divisional fire officer.
And is that the criterion you apply when you say that Mr. Lane didn't satisfy it?
That is correct, my lord, on either score. If we applied on either score, my junior Ms. Blackstock has done up a table, and correct me if I'm wrong on that in due course, but we say the criteria on the state's evidence, what we submit is on their evidence. It is not in dispute that Mr. Lane did not meet that particular requirement, and I'll come to that to show you that that is conceded, my lords.
All right. And can you point us to the document from 2015 which set out that requirement?
Absolutely, my lord. I'll come to it, my lord, certainly. So, my lord, just to complete the significance of this particular document, what we say is it adds insult to injury to exclude us from this interview. Rank someone who's junior to the appellant, and then use this as a springboard, this order of meritless. You then use this as a springboard for giving Mr. Lane acting appointments on the basis that he now has a place on a meritless, and then turn around and use the very experience he's gathered by virtue of those illegal acting appointments to say, well, look, he now has acting experience, and that counts for other forms of career advancement to the detriment of the appellant. My lord, we only learned about this when we got the affidavit evidence filed by the state. We didn't, the appellant did not even know that this existed. He did not, because he was not invited or told about this interview at all. So we say that this meritless, really, insofar as Mr. Lane goes, it is the fruit of a poisoned tree. My lord, it's important. Can I take you next to page 696?
So just before we move on from the order of merit in 2015, I think it's said on the other side that there hasn't been a challenge to the validity of that order of merit.
No, and that's correct, my lord. One couldn't possibly challenge it when it was, by the time it came to evidence many years after, it was long expired, used and done with. It would have been pointless to challenge it, my lord. But what we do challenge is we challenge the use to which the state is putting it to the detriment of the appellant. But there would have been no point challenging an expired meritless ex post facto so many years after the fact.
Yes, all right. So page 696, I think, is the next.
Yes, please, my lord. 696 is the fire service order that effected the promotion to the rank of divisional fire officer. And you will see at the third name is your humble appellant, Mr. Ramsaran. He was promoted with effect from the 4th of February 2016. And if you check 4 lines down, Mervyn Lane, you will see he was promoted with effect from the 8th of February 2016. Now, my lord, in the civil service in Trinidad, 1 day that separates officers makes a difference. That's just a culture. But it's very significant that the gap is a significant number of days, because you would normally have many officers being promoted on the same day. So that's the situation. It is not in dispute that insofar as the seminal rank of divisional fire officer went, the appellant was senior to Mr. Mervyn Lane. And this is the document that establishes that. I then take you, my lord. So, and we say that all acting appointments made after this order, and this order is dated, it's dated March 10th, 2016. So the acting appointments that took place thereafter in 2016, 17, 19, and 2020, and so on, we said that all of that ignored the relative seniority of the appellant over Mr. Lane, and wrongly so. Now, my lords, I take you next to...
Right, and at some point you're going to show us the legal significance of the order of seniority, are you?
Yes, well, my lord, yes, I'll come to the regulations, because, my lord, interestingly enough, there is no mention of a seniority list in the regulations.
No, I think that's a point that's made against you.
Yes, and my lord, well, and we respond by highlighting the criteria in which the issue of experience, which translates into seniority, is in fact a relevant consideration to which the commission has to have regard. So it's not that it's not there. It is there, and it's a relevant. It's highlighted expressly so as a relevant consideration. So that's our response to that in short. My lords, can I take you next to page 83?
83.
Yes, please, my lord. This is the amended claim, and the claim had to be amended because of the piecemeal manner in which the evidence came from the defendant and what it revealed to us for the first time. So there was a hotly contested application before the judge for leave to amend, which she eventually granted. And it is on that basis, you will see the way the claim is structured, as we have dealt with by his being bypassed for appointment of Deputy Chief Fire Officer after August 2019, and we deal with pre-August, prior to August 2019. You will see that at page 86. So we split the case into two parts because in August 2019, he would have completed the IBCC course. And that is what they told him constantly was being held against him. And that was the impediment to him being considered for promotion. So that's why we split it in two. Can I take you to page 962?
Right. So I'm just a little bit unclear. You're showing us page 83 and 86, what, just to show us that the claim was split into these two time periods. Is that right?
Yeah, that's correct, my lord.
Yes,
just to set the stage for that, yes. Because the claim is split into those two phases, and then we've got the constitutional element of the case, which deals with the right of protection of the law and equality of treatment. So, my lord, I take you next to the letter starts at page 960, and it's a response to the pre-action correspondence. And if I take you at page 961, you will see at page 961, second to last paragraph, the office of Deputy Chief Fire Officer became vacant as a consequence of the retirement of Mr. Roosevelt Bruce from the fire service with effect from October 13th, 2019.
I'm so sorry. Where are you reading on that page?
The second to last paragraph on the bottom of the page, my lord. Page 961.
Yes, got that. Thank you.
So I want us to note the date from which the office had become vacant, October 13, 2019 in this instance. And then we are told on the next page, 962, by memorandum dated 23rd of May in 2019, Mr. Ramsaran was informed of the reason he was not selected for the acting appointment in the office of Deputy Chief Fire Officer at the time it occurred. He was not in possession of the required brigade command course or its equivalent at the time the acting appointment arose, as at March 18, 2019. Neither did he satisfy the experience requirement of at least 6 years at a senior managerial/administrative level. Now, I'll take you to that letter to show you what it actually says compared to what they have claimed it says. And they said it is therefore not correct to state that Mr. Ramsaran was not allowed to make representations in respect of the acting appointment as Deputy Chief Fire Officer. In accordance with Regulation 155.3, he was given 7 days to make representations regarding his non-appointment to the office. Now, my lord, this is an important part of the case because the regulation contains an important procedural safeguard that allows an officer who is eligible to be considered and being bypassed to be notified and allowed to make representations on his own behalf. Can I take you to this letter? It's to be found at page 741.
741.
741, 741.
Yes, thank you.
Much obliged. And my lord, you will see, this is a letter.
Oh, something happened to my computer. Just one moment.
Sure, my lord.
Yes, I think. Yes.
It's a memorandum, is that right?
That's correct, my lord. It's a memorandum from the Chief Fire Officer, and it's to the appellant. And it says, your application for the acting position of Deputy Chief Fire Officer is acknowledged. In accordance with Regulation 160, you were not considered suitable at this time as you do not possess the necessary qualifications, namely successful completion of the course as stipulated by the job description. There are several things to note about this. One, there is no mention of the equivalency assessment, because this is a man, you will see from his resume, had been constantly trying to better himself and had accomplished a range of courses. So the equivalency assessment is completely omitted, and clearly they didn't address their mind to it. Secondly, there is absolutely no mention about the experience requirement. Contrary to what they paraphrased and said in the response to the pre-action letter, there is no mention about an experience requirement. And thirdly, most importantly, there is absolutely no mention about you're invited to make representations in accordance with Regulation X or Y. Nothing of the sort. So that it's a bit disingenuous, to say the least, to respond to the pre-action and in the evidence you will see, to suggest that this letter can somehow be amplified and stretched in such a Procrustean manner to yield an answer that will service those legal requirements. It just doesn't get off the ground, my lords.
Well, except that Regulation 1553 at page 1722 just says that the Chief Fire Officer shall allow a period of 7 days to elapse after the issue of the notice to allow for a challenge. Are you saying that that didn't happen?
No, well, my lord, I think on a purposive construction, one would have to see that that regulation properly read would have to include that the Chief Fire Officer will have to inform the officer that, look, you have a right to make representations, or else, you will see everything operates retroactively. Nothing operates in a timely manner. So it's a very dangerous thing to say that it's a simple matter of allowing 7 days to elapse in complete silence, and then you can do as you please. But I take the point that the regulation does not specifically impose that duty in a positive manner, but on a purposive construction, my lord, and having regard to what they themselves claim that it was intended to accomplish in response to the pre-action letter, I dare say that it's conducive to the interpretation that we advance in terms of and it's illustrative of what should have in fact happened. If I take you back to page 962, just to revisit, make good that point, you will see that they say that by memorandum at the top of page 962, they say that by that memorandum dated May 23rd, he was informed that the reason he was not selected is because he was not in possession of the course or its equivalent. That's not true. At the time of the acting appointment arose, and neither did he satisfy the experience requirement for the office of at least 6 years. That's not true either. And then they say it is not correct that he was not allowed to make representations in respect of the acting appointment. In accordance with the regulation, he was given 7 days to make representations regarding his non-appointment. Now, my lord, this particular protection governs all fire officers, but it would be rendered, the procedural safeguard will be rendered ineffectual and completely undermined unless, as a matter of fairness, we impose a duty on the chief fire officer to simply, in that letter, end it by saying you have the right to make representations within 7 days pursuant to Regulation X.
Could you help me in relation to one matter, please?
Certainly, my lord.
Yeah. Is there any case law in relation to, for instance, rights of appeal, which requires people to be informed about their right of appeal? I'm thinking in terms of employment situations where someone's dismissed and they have a right to appeal to some other body. My recollection is there is case law to the effect that they have to be so informed. But I was wondering perhaps if you could, whether you know of those authorities.
Yeah, my lord, that is an established part of the jurisprudence in Trinidad and Tobago. It's the leading case, the case of Vijay Bola, and the Court of Appeal has decided in precisely that context that fairness requires that laypersons be informed specifically about these rights that the law would confer upon them, because it would be it would not be in accordance with common sense and practical realities to expect that members of the public will know the law to that extent, and it will deprive them of important procedural safeguards unless they're specifically told. So in the interest of fairness, in Trinidad and Tobago, the law is that you must inform them. A more recent example it would be under the Freedom of Information Act, for example. You have a right to appeal and a right to seek judicial review, or a right to go to the ombudsman. And again, you'll have to inform them about that and not assume that they will know about it. So the analogy is a very apt one, and I say it for the same reasons that we impose such a positive obligation, bearing in mind the wide spectrum of educational level and ability from the lowest to the highest in the fire service. We must err in favor of giving life and meaning to this procedural protection by saying that the chief fire officer ought properly to have simply informed the officer of his right to make representations, and the failure to do so was manifestly unfair.
Are those authorities in the bundle?
No, my lord, but we can certainly furnish.
Thank you very much indeed. Thank you.
I'm so sorry, Mr. Ramlogan. I'm so sorry, the board, to interrupt something I very, very rarely do. I'm just slightly concerned. I'm not. It would be helpful if Mr. Ramlogan at some point could help me when I respond as to where this was ever run below at any point. It seems to me, as far as I can tell, a completely new point, and there are quite a few points in the case already.
Yeah. Well, my lords, in answer to that, the case was run in the court below on the ground of unfairness, and in terms of the breach of the right of protection of the law, that the whole system and practice and procedure that they had adopted in relation to these matters was one that reeked of arbitrariness and unfairness, and therefore violated the right of protection of the law. And the grounds are pleaded in the amended statement of case, and we specifically allude to these matters. But again, bear in mind that we would have only been confronted with this evidence in response, because we would not have known about these matters. And one of the complaints we make very strongly about the respondent in this matter is the absolute lack of full and frank disclosure. There is even now, there is no clarity in the evidence on critical matters. And these are matters that lie within the bosom of the respondent, the state.
Well, if the brigade command course was a necessary requirement, I'm not sure that representations would have done much good. The more important point may be that there was no mention of managerial experience in the memorandum that was sent, but that seems to have been, although that was suggested, it seemed wrongly, in the letter.
Well, Lord, with respect, I appreciate that, but remember, I highlighted specifically that the equivalency issue was not dealt with at all. And
well, do you have a case? We've got about 100 points in this case, but is the equivalency point one of them? Are you saying that there were equivalent qualifications that he had and that those should have been considered? Is that one of your complaints?
I'm saying that, my lord, had he been given the opportunity to make representations, that
Well,
would
is
be one of
it
the-
a case that it would have done him any good? But did he have equivalent qualifications? Is that one of your numerous arguments?
Well, my
If
lord, yes,
not,
it
you'd
is.
be more helpful if you stick to the battery of arguments that you already got.
Well, my lord, respectfully, I put it this way, my lord. If he had been informed of his right to make representations, given the equivalency alternative, one of the representations that he could have made quite easily is, look, I have alternative qualifications.
Is this in your previous arguments? Is this a point you've been arguing up to now? Or is it a
Yes,
new
my lord.
one you're now introducing?
No, my lord, this is a point we did take in the courts below, my lord.
Right. So if you could show us the pleading for that, that would be helpful.
Well, certainly, he set out all his qualifications in his affidavit, but I didn't gather from that affidavit that he was stating that they were equivalent to the IBCC qualification.
Well, my lord, to be quite frank and to be fair, I don't think I went that far.
Yes.
And I'm prepared to concede that. But what I do say, even that, I mean, that would be the equivalency assessment would be a matter for the commission and the chief fire officer. But the short point I'm making is not having, it's clear that they themselves did not consider it in light of the plethora of qualifications that he did have.
We don't know because they haven't, the allegation hasn't been made against them and they haven't responded to it. So,
well, my lord, fair enough. But had they considered it, it would have obviously been expected to form part of that very letter to which I took.
Part of the difficulty
now.
of this case, Mr. Ramlogan, is distinguishing the wood from the trees on this appeal.
I hear you, my
And
lord.
it will be helpful if you will focus on the points that you think are going to get home, rather than points that end up going nowhere.
I think the essential point you make is that the requirement, suitability, eligibility, definition of 6 years experience, managerial experience in a senior level is completely vague and leads open arbitrary decisions. But what I'd be interested in, who devised that? The advert comes out, the employer is the fire service. The advert is put in by the chief fire officer, and it is the chief fire officer who subsequently says that the appellant is eligible once he obtains the BICC qualification. And so who was it who devised the criteria, the job specification?
Well, my lord, that is also a bit of a mystery.
Yes.
Because the state has not clarified that, and as to whether it is the commission, the Ministry of National Security, or the chief or the fire service itself, we don't know.
Can you point us at least to the bundle page where we see the requirements set out?
737.
Sure. You mean the job description, my lord?
737. Is 737, is that the document?
Yeah.
Yes, my lord, that's correct, my lord, yes. This is the job description for Deputy Chief Fire Officer, and you will see under Education, Skills and Specialized Techniques, the Brigade Command course from the United Kingdom or equivalent, but we are not told what would be the equivalent. And then if you scroll down on the experience at the bottom of page 738, you will see 16 years experience in the fire service, including at least 6 years at a senior managerial / administrative level. Those are the relevant requirements that are in play here.
Yes, thank you.
Much obliged. Now, can I,
And was there an application by your client? Here's,
well, yes.
sorry?
Yes, my lord, yes.
Yeah. And where do we find that in the bundle?
Well, my lord, we don't have the application because that would be submitted to the state. But what we do have is the letter in response to which I alluded, where we have told, well, look, you didn't meet the requirements. So can I take you next, my lord, to page 931.
And sorry, can I just check, what is the date of the document at 737?
Second.
I think.
No, there is no date on the document.
Well, can you, are we told in the Statement of Facts and Issues when it was issued?
No, on the for a date, there's no date, and we did not could not agree on any evidential date that would be helpful to the board in terms of this. All we can say is that this is what the respondent put in as the job specification.
Yes.
That was relevant at the material time.
They say that at page 887, paragraph 13, and the advert from recollection is at page 916, if my note is correct.
Yes, that is correct, my lord.
Or, well, that's a. Sorry, that's a station notice.
Yes, indeed, my lord.
Is it common ground that your client was provided with a copy of the job specification that we've just been looking at?
No, my lord, it's not common ground, no.
Sorry, I didn't hear that answer.
It is not common
No, my
ground,
lord.
you said.
No,
Right.
it's not.
Well, what is your position? Was your client provided with the document at page 737, the job description, or not?
My lord, I don't believe the appellant was provided with a copy of the job description. And we will confirm that in the affidavit evidence, but no, it was not provided to the client.
So
When you got the notice on 7916, presumably, which refers to a job description.
Yes.
So, did he get a job description? Or did he ask for one? I mean, it says you would have thought the first thing you do if you're going to apply when you see this station notice is to get hold of the job description.
Well, Lord, I presume. I mean, I'm prepared to presume that he would have been aware of it. As to whether or not he received it, but I mean, he must. I see the force in what my lord is saying. As a matter of common sense, one would expect that it would have been published and he would have known about it.
Okay.
So I'm prepared to proceed on that basis, my lord. My lords,
and can I just check? So there was a document which was your client's application for this job. We just don't have that document. Is that right?
yes, because that document would have been submitted to the state.
Right. Okay. And does the appellant deal with what he said in that document in his affidavit?
No, please, my lord.
Right. Thank you.
But my learned junior is saying at page 668, paragraph 12.
I'm sorry, I missed the page number. If you could give that again.
It's page 668, paragraph 12 of the affidavit. We are told that on the 6th of May 2019, an acting appointment for the post of Deputy Chief Officer was internally advertised for interested and qualified applicants to apply for acting appointment.
And this document is this one of the affidavits of your client? Yes, thank you.
Indeed, my lord, yes. Well, can I then press on to page 931? At page 931, it's a memorandum from the Chief Fire Officer dated March 17th, 2020. And it says that it's to the Permanent Secretary in the Ministry of National Security. Now, my lord, we're told that a conversation on this February 27, 2020 took place between the Human Resource Officer 3 concerning the apparent overlooking of Mrs. Arnold Bristow, the appellant, and Andy Hutchinson for acting appointment in the office of Deputy Chief Fire Officer. Please be informed that at the time that Mr. Mervyn Lane was offered the acting appointment, he was the only one who possessed all of the necessary qualification for the office, as is outlined in the job description for the office of Deputy Chief Fire Officer. And my lord, the use of the word all, the necessary qualifications, we take issue with this letter because Mr. Lane did not satisfy the experience requirement. And I think that is not in dispute by my learned friend. So this letter is misleading.
Sorry, Mr. Ramsaren, just so you know, it's being indicated that is in dispute. So I think it is being maintained by the state that Mr. Lane did have all the requirements.
Well, my lord, I'll come to that in due course. I beg your pardon. I'll come to that in due course. Lord, can I just take you next to page 866? At page 866, we have a letter of March 18th, 2019 from the Director of Personal Administration to the Ministry of National Security. And you will see that it says Mr. Bruce proceeds on pre-retirement leave from today being March 18th, 2019. And we're told, and this is important, it says, based on seniority, Assistant Chief Fire Officer Smith will be appointed to act as Chief Fire Officer and Brigades Engineer Mr. Bristow as Deputy Chief Officer. The words based on seniority is important because the regulations doesn't in fact sanction that. But if that is the policy and practice, the question is why was it disapplied in the case of the appellant who was senior to Mr. Lane at the rank of Divisional Fire Officer, which was the seminal rank that was the springboard for everything else that occurred. Then we scroll down to the next page. We're told that Mr. Bristow, they said that Mr. Bristow, at the bottom of the at page 866, they say that Mr. Bristow has spent his entire career, on page 867 at the top, he spent his entire career in the engineering section and has never managed a station or division. A fire service is way beyond his competence. They therefore recommend Mr. Mervyn Lane to act as Deputy Chief Fire Officer upon my departure. And it's based on the fact that Assistant Chief Fire Officer Smith is relatively new to the position and is focused on his studies at the university, majoring in agriculture. And Lane has grown up in the administrative sector of the fire service from an apprentice to the period he acted to the Deputy Chief Fire Officer on merit. He has commanded divisions during his tenure and has always performed with distinction, and he's been exposed to numerous overseas courses and has successfully completed the courses. Now, there is no mention. They mention the bypassing of Mr. Bristow and justify the bypassing of Mr. Bristow. But there is absolutely no mention about bypassing Mr. Ramsaran, the appellant. So he is completely excluded from consideration. He's not featuring on the radar at all. And that we say is illustrative of how he has been treated throughout.
But this is before, is this before the competition that he was not selected for?
Beg your pardon, my lord?
Is this before the notice that we saw and the job description and so forth? It's 18th of March 2019.
Yes, and remember, my lord, that's why I drew attention to the fact that the case is split into two time periods, pre-2019 and post-2019. So this would be relevant to the pre-2019 period, because we say even during that period, it was wrong to not consider him in accordance with the.
I know, but there you have to get over the fact he didn't have the brigade course exam.
Yes, and I intend to get over that, my lord, by showing what the law required them to do, and we'll come to that in due course, my lord. Can I just take you to page 9?
Well, just before you do, could you just tell us what you say is the date of the pre-August 2019 competition and the date of the post-August 2019 competition, just so we can note it?
Yes, in terms of the, my lord, in terms of the, my lord, we say that from the date when our client attained his position as divisional fire officer, which was with effect from the 8th of February 2016, he was senior to Mr. Lane, and from that time onwards, he deserved to be considered for acting appointments in priority, in competition with and or in priority to Mr. Lane.
Yes, and when were the competitions? That was my question. What was the date of the relevant competitions, both pre-August 2019 and post-August 2019?
My lord, there are numerous acting appointments, my lord.
But the ones that we're concerned with are in May 2019, aren't we? The one that he got the memo telling him that he hadn't been eligible because he hadn't passed the exam, when he asked why he wasn't considered for that. And then there's a later consideration, I think, which we haven't come to yet, but which was a sort of retrospective appointment of Mr. Lane, I think, that was made in April 2020, something like that.
Yes, my lord, I think that's about right.
Yeah, so we need to focus on those and what you say about those.
Sure, my lord. Can I?
So far, I can't see the answer to why, for the first time in May, the fact he didn't pass the exam isn't an answer to that complaint. And then when we come to the next, I'm interested in the point about whether the job requirement of managerial experience was a real requirement or just something that wasn't justified.
Sure. Well, my lord, the answer to that lies in the regulations. The regulations did not require and did not prescribe this course as a mandatory requirement and a prerequisite to be considered for an acting appointment. And the fact that you superimpose this as a matter of administrative discretion doesn't, without amending the regulations, creates some problems, because that is precisely the kind of arbitrariness that having a detailed code of regulations was designed to prevent. And I'll come to that in due course.
Well, your due course is reducing in time, so you're going to have to focus on the points that you want to emphasize.
Sure, my lord. My lord, can I go to page 916?
Page 916.
Yes, because I do want to at least complete my tour of the evidence, my lord, before I get into the regulations. At 916, we see this is the advertised vacancy for chief and deputy chief fire officers, and it deals with acting appointments. And I'd like to highlight the distinction between acting appointment and promotion, because there may be different considerations that apply to acting arrangements as opposed to promotion. But we're told that applicants must satisfy the requirements in accordance with Regulation 158 as amended and the respective job description. And this is dated May 6th, 2019. We say this is important because if the applicants were told that they had to satisfy the job description, and we see that Lane did not satisfy the requirements in the job description, then he ought not to have been considered. It's either both of them should have been excluded from consideration, but one couldn't be considered without the other, whilst ignoring the other.
Well, except that Lane had passed the brigade course and your client hadn't.
Well, but yes, but it says that you must satisfy the requirements of the job description. The requirements, plural, would include also the experience requirement, and we say he didn't satisfy that.
But that's disputed. It said that he did.
That depends on what it means, partly, doesn't it?
Well, it depends on what it means, but it also depends on what's the rank from which you measure the requisite experience, and that is a matter of heavy contention.
Well, to my mind, they've seemed to have elevated the experience requirement into a requirement. There are lots of other requirements there. First aid, sound counselling skills, whatever that means. And so I just can't understand at present how the respondents elevate one as opposed to other requirements.
Indeed, my lord. When we look at the range of criteria that the regulations require you to consider in making a decision, it is not one to the exclusion of others. What they want is it's like a 360 degrees evaluation of the person, because you may have different strengths and weaknesses in different candidates.
Yeah.
And the point is they have devised a system that is completely at odds and impossible to reconcile with what the legal regulatory framework prescribes and should have governed this entire process.
Well, you say that. Are you going to take us to Regulation 158? Shall we look at that now at page 1723?
I'm not sure. Can I, my lord? Yes, we can do that now.
Because if one looks at Regulation 1583...
Sorry, what's the page, my lord?
1723. Or indeed, Regulation 1581 says, in considering eligible fire officers for promotion, the Commission shall take into account the experience, educational qualifications, merit and ability, together with the relative efficiency of those fire officers. So there's an express reference there to educational qualifications.
Yes, but the point is it doesn't single out any particular qualification. And the point is you would have to weigh in the balance in deciding on the competition. You'll have to weigh in the balance, the appellant's qualifications, basket of qualifications as against Mr. Lane, and you will have to weigh them up. But there was no weighing up exercise because they just simply excluded him from consideration because they amended this regulation in their minds and replaced any special qualifications with the IBCC course.
So your complaint is quite simply that they just excluded him without actually carrying out a comparative exercise. And
Yes.
and
Well,
I'm sorry. For all we know, he may have lost that, but all the same, he was entitled to being considered.
Because that is what the law requires. I mean, you have
But forgive me, Mr. Ramlogan, surely they did do a comparative exercise because they told him that he wasn't appointed because he didn't have the BCC qualification. So they'd obviously looked at his qualifications and didn't think that they were good enough.
Well, no, my lord, no. With respect, the evidence is that they excluded him because he didn't have the course. They interpreted and elevated that course as a mandatory precondition to go forward. It became the preliminary, it became the hurdle that he had to cross, and there is no evidence whatsoever from the respondents that they applied this criteria to the appellant, because they didn't. What they did is to superimpose the course as a preemptive requirement, and if you didn't, it's either you had it or you didn't. And if you didn't have it, that was the end of the matter. The guillotine fell.
But why under Regulation 1581, is it not permissible for the Commission to specify the educational qualifications that will count for a particular promotion because of the importance of those qualifications for that promotion?
My Lord, the reason that is not as simple as it sounds is because the previous regulations, which were repealed and disapplied, had a provision like that, but was expressly omitted from these regulations after the disapplication. I can take you to that, my Lord, in it's to be found at if I try page 1679. Yeah, in 1679, this is the regulation that was disapplied. It's Regulation 18 under the Public Service Commission regulations, and when it applied to the fire service, you will see it's a similar approach, same statutory criteria, but when you get to the end of it, at the end of 3 with A to L, you will see sub-regulation 4, which says, in addition to the requirements prescribed in sub-regulations 1, 2, and 3, the Commission shall consider any specifications that may be required from time to time for appointment to the particular office.
1679.
That was deliberately omitted when this particular regulation was disapplied and reenacted in the one that we just looked at, my Lord.
So what's the date of this regulation that you're showing us that starts on 1677? And it's the passage at 1679 that you're calling our attention to. When were these regulations in force? And I think you said that they were disapplied. How were they disapplied?
Yeah, my Lord, can I take you to page 1057 where we've dealt with this extensively? It starts at page 1. We've dealt with the history of the regulations. And at page 1057, you will see at paragraph 11.
And this document, just assist us, this document we're now looking at is what?
It's the case for the appellant, my Lord.
Ah, I see. This is your case before us.
Yeah. And we started off by detailing the history of the regulations. And you will see at paragraph 11, we say, by legal notice 282 of 1998, dated 20th September 1998, the Public Service Commission regulations were amended to insert Regulation 2A, which disapplied regulations contained in Chapter 3 to Chapter 6 in respect of the fire service on the commencement of the fire service regulations, and to revoke and replace Chapter 12, which thereafter dealt exclusively with the fire service and includes the selection principles for acting appointments in regulations 154 and 158. These disapply regulations 18, 24, and 26. Notably, no distinction is made between acting appointments as a prelude or as a non-prelude to substantive appointment in this for the service. Certain specified regulations continue to apply to the fire service, none of which are relevant to these proceedings. So, my Lord, it is the replacement, it is the new regulation that we're concerned with. And my submission is simply this, my Lord. These amendments were prompted by a lot of complaints about arbitrariness and bias in the promotion procedure. So what they tried to do is to eliminate the fertile soil for that kind of arbitrariness by having a more specific, clear, and predictable procedure.
But if I may say so, Regulation 1581 is not particularly specific. It lists a number of factors which are themselves unspecific as to the content of them: experience, educational qualifications, merit and ability, and relative efficiency.
Yes, well, Lord, well, it's specific to the extent that it allows you to know the broad criteria that they will have to consider. But my Lord, that's not to the point with respect. The short point is you've got a basket, a spectrum of statutory criteria to which the Commission must apply its mind in respect of an eligible officer to decide in competition, to weigh and analyze and balance in competition with others.
Yes, but forgive me, but just focusing for the period before August 2019 and the competition in May 2019 that we're looking at for that period, why was it not permissible for the Commission to say, under educational qualifications for this particular post, they regard it as particularly significant that someone should have the BCC qualification?
Well, my Lord, the problem with that analysis it rests in the words in the addendum with or equivalent. You see, if they didn't have the equivalent, we can say that they've specified a singular course to which they've addressed their mind as the be-all and end-all of it, but they didn't.
I think your broad submission, if I understand it correctly, is that the statutory scheme required a holistic assessment of all the relevant criteria, and they couldn't simply shut somebody out by adding on some additional necessary condition and saying that because he hadn't satisfied that, he didn't even get in the door for consideration. That's your argument, is that right?
Indeed, yes, that is correct. They elevated it as a mandatory statutory precondition almost, without which you couldn't go forward to have this statutory criteria applied to assess your merit and ability for acting appointment, and that's wrong.
And I also understand another point you're making is that there is absolutely no evidence at present before us that the Commission did regard it as a particularly significant qualification, because we don't know who imposed this condition at all, whether it was the Fire Service, the Chief Fire Officer, or the Commission, or what consideration was given to it, when and by whom.
Or even if it was significant, it seems to have been regarded as a prerequisite, and that maybe that was you say not appropriate.
Yeah, I mean,
could have been outweighed by other factors.
Yes, because, my Lord, one has to be careful, my Lord. Look, can I say this? In these protective services in these small islands, one of the problems we face is that you have people who are extremely well qualified sometimes, but they're people who exist in air-conditioned offices but don't have any operational experience on the ground, and they can't actually man the services. And then you create situations where people with operational experience sometimes have to be given better priority than those who have many letters behind their name because they were hiding from the real work on the ground to get those qualifications in air-conditioned offices. And you will see that from the comment they made about the guy who's studying for his agricultural degree earlier on. But my Lord, that's why these regulations adopt this approach of having this holistic approach to evaluating people, because one criterion might commend a particular officer with far greater weight than an educational qualification. And one has to be careful. I mean, the Chief Fire Officer, for example, in justifying his recommendation, said, well, he did a great job in administration. Well, that's fine, but I mean, there's a lot more to be said, quite frankly, for those who are on the ground fighting the actual fires and climbing up the ladders and saving lives.
Right, but
I mean,
can I just be clear, Mr. Ramlogan? As I understood it, your argument in relation to Regulation 158 on page 1723 is that, in effect, what was being done was setting up an eligibility requirement based on an educational qualification, that is, that the course had to have been completed, and that you say you cannot create that eligibility requirement without contravening the regulation. Is that right?
Yes, I say so, my lord, because it became a mandatory precondition and a filter without which you couldn't access your right.
And the argument against that is that eligibility can include job specification, and that is a sensible way to proceed, that it is perfectly consistent to put forward part of at least the job specification as an eligibility requirement. I mean, nobody's disputing that under Regulation 158, it's a discretionary decision based on those factors. I thought your argument is about the prior position of what counts to get to that consideration, i.e. eligibility, including part of the job specification. But have I misunderstood?
Well, what we say is educational qualification is a listed criterion, and it's something that you have to consider. But the structure of the regulation is such that it's meant to be a holistic assessment of the candidate's merit and ability by reference to this statutory criteria. It was not meant to be that you cherry pick one and that became a gateway to exercise your right to be considered in accordance with the statutory criteria. So if you look at it, qualifications, as it were, is obviously something that one, that the commission will have to take into account. No one is saying no to that. But what you couldn't do, in my respectful submission, is to isolate one particular condition and use that as a mandatory precondition, without which you can't go forward in any form or fashion. I mean,
but isn't that the point? Isn't that the central point we have to decide pre-August 2019 whether you're right about that? Because certainly the first instance judge and the Court of Appeal both think you're wrong.
Yes, and my lord, we say we're not. We say that on a purposive construction, the correct way to interpret this is that you're meant to consider the qualification, the basket of qualifications that the individual has as part of the holistic assessment of the candidate to determine their merit and ability. And we say that it's taking it too far to have that, to take that approach as they've taken. But more importantly, my lord, remember, even if they're right on that, my lord, we still have the problem with the equivalency, because they themselves on the evidence concede that it's not simply this course, it says or equivalent. And how are you going to assess the equivalency of, except by reference to the other qualifications and courses that the man did? So that, it brings us right back to square one.
But I thought you told us earlier on that you don't have a case on equivalency. You didn't run a case on equivalency below.
Well, my lord, no, my lord, with respect, what I'm saying is that I'm making this submission.
Can you show us where the case on equivalency is pleaded, just so that we can understand it? If you could show us where your case on equivalency is pleaded, please.
No, my lord, I'm not saying that I pleaded that. My lord, what I'm saying is I'm making that submission in support of the correct statutory interpretation for this particular regulation. That's the submission I make.
All right. Can I just ask you about your interpretation of Regulation 158? Because your holistic approach, as you say, is mandated in all circumstances and can't be overridden by anything in the job specification. Seems to be, to me, to be a recipe for arbitrariness and capriciousness in the approach of people considering eligible fire officers. Might it not be said that specifying with greater detail in a job specification what would be expected is a way of making the appointments process less arbitrary and would be in conformity with what is permitted under Regulation 158(1)?
Well, my lord, if that is what the regulation intended, my lord, then what will happen, my lord, is that, can I take you to show you where when they intended for a particular qualification to be treated in that manner, my lord, they did so expressly. Can I take you to page 1604, for example, please? Let's look at Regulation 9. This is the current law. And it says in Regulation 9, and this is, it says a candidate for appointment to assistant to the office of Divisional Fire Officer shall be selected from among the persons holding the office of Fire Station Officer or Fire Equipment Supervisor with at least 10 years in the service. So they prescribe the experience requirement. Right. A fire station officer or a fire equipment supervisor, in order to be a candidate for appointment to the office of Assistant Divisional Fire Officer, shall possess the following qualifications: 5 subjects, GCE, General Diploma from the Institution of Fire Engineers, Diploma from the Joint Staff Services Staff College, successful completion of the Overseas Command Operational Fire Prevention course, pass a written exam in English language. And then they say this: a candidate for another office in the 1st Division shall have the qualifications prescribed for the office of Assistant Divisional Fire Officer and shall have served in that office. So the regulations addressed the matter. It's not that it's silent on it and left it and gave a blank check to the Commission.
If I may say so, I'm not sure that that's meeting the point that I was putting to you, Mr. Ramlogan. No one is disputing that at points in the regulations, a different drafting approach is adopted where the regulations themselves specify particular requirements in a very detailed and specific way that have to be fulfilled. And I think Regulation 9 is an example of that. But my question was about Regulation 1581.
Well, my lord, I'm answering that by saying, my lord, that this regulation applies to it applies to the offices we're talking about. If you look at sub-regulation 3, the regulation says that a candidate for another office in the 1st Division, and the 1st Division begins with Divisional Fire Officer and ends with Chief Fire Officer. So the regulation itself tells us what are the qualifications.
But it doesn't say those are the only qualifications. It says they shall have those qualifications. There's nothing preventing further qualifications from being added to the list. And
I accept that.
And
I accept that. I accept that. But the point is, the point I'm making, my lord, is that insofar as the law intended to prescribe a minimum mandatory requirement in terms of a qualification, it did so. And it did so by virtue of sub-regulation 3. And what is the minimum below that they wanted? The minimum was the qualifications prescribed for the office of Assistant Divisional Fire Officer.
Right.
Your case is on the proper interpretation of the regulations. If you've got those minimum requirements, that's the eligibility threshold. And if you meet those, then they should do a holistic assessment of which any other requirements, if you want to call them that, or criteria, must only be part of the picture. They can't be prerequisites to consideration. It matters to take into account in the consideration, you say.
Indeed, my lord. That is our case.
you've got no objection at all if they had, in fact, gone ahead and considered your client's application and then put particular weight on some factors in that list adverse to your client, you'd have no argument. So
none whatsoever.
Yeah.
Right. Well, I'm struggling to see why the facts don't show that that's what they did. They say in the job specification, we're going to attach particular weight to whether you have the qualification. Why can't they do that?
Well, my lord,
In their holistic assessment, if they can place weight on any particular factor, that's what I'm understanding you to mean by holistic assessment. You can pick out what's important in the particular circumstances of the particular job. Why can't you pick out a particular educational attainment as being particularly important for that job, and tell the world, if that's what you're going to do, you tell the world that's what we're going to attach weight to.
Well, my lord, I think the weight that has to be attached to it is weight that has to be attached in the context of applying the statutory criteria as a whole. What you can't do, my lord, is to say, look, I'm going to cherry pick one and elevate it to the status of a statutory mandatory precondition. And that's what they did. The evidence here is that they didn't really apply the statutory criteria. What they did is to say, look, it's either you have this course or you don't, or the equivalent, or this ill-defined equivalent, and that's the end of it.
Is the only evidence we've got of what they did the memo of the 23rd of May 2019, or is there any evidence of their consideration beyond that?
There are repeated references that confirm and reconfirm that what they did is simply to tell Mr. Ramsaran he didn't have the course, so that was the end of it.
Right.
And I can take you to some of those references, my lord.
Well, just before you do so, the job specification doesn't weight the various factors at all. It just sets out all the various factors. And the weighting is usually done when you have an interview with somebody or you consider their application. And
Yes, my lord, I concede that weight is a matter for the commission, but the point is the weighting process, the weighing up, as it were, has to take place in the context of the holistic approach contemplated by the regulations. And my lord, and I say this that there's for good reason, because in the protective services in these small islands, there would be, you might be surprised to know that some of the other criteria might actually, you might attach greater weight. Let's say, for example, performance appraisal. I mean, if a man has an exceptional performance appraisal report because he rescued many people from burning houses and so on, that might make that person, get some special points that a man with a degree, for example, who was in an air-conditioned office shouldn't, because the men on the ground will respect the guy who had that operational experience far more than they will the guy in the air-conditioned office who got the degree.
I'm sorry to interrupt you, but could you just help me in relation to one matter? And that is the office was filled in June 2019, but there was no meeting of the commission until the 28th of April 2020. Who was it? Who was it who appointed Mr. Lane as the Deputy Chief Fire Officer in June 2019? Did he just move into the office, or was he just told by the by the Chief Fire Officer, or what? What led him to take up this position, which was had to be approved by the Commission?
Well, that's one of the mysteries and the evidence in this case that the state did not condescend to explain, because it appears to be a retroactive appointment. But of course, the problem with that retroactive appointment is that there would have been no advertisement, no notification to eligible officers, and a complete wholesale breach of the regulatory framework that was meant to fairly administer the opportunities for career advancement in the fire service.
But there was a notice. We saw the notice that was the advertisement on the 6th of May 2019. So what was the appointment process that followed that?
Well, there's a paucity of evidence on the matter. All we know is that at some stage it would appear that there's a retroactive appointment that is gifted to him. That's all I can see.
Well, my understanding of the evidence is that Mr. Lane just walked into the office, presumably as a result of some conversation with somebody, but not on the basis of any appointment having been made by the Commission.
That is correct. That is correct. That is correct. It's the height of arbitrariness, and because there is no letter, there is no evidence from the Commission that they authorized it, they sanctioned it, they approved it, nothing of the sort. Nothing of the sort.
Well, there's no evidence from the Commission that they actually approved the job specification either.
No, indeed, no. My Lord, can I go to page 947? You will see, my Lord, at 947, this is the date of the letter, July 23rd, 2020. And they say, Public Service Commission has appointed you to act as Deputy Chief Fire Officer for the following periods. They are now appointing in 2020 retroactive appointments, 2017, 2019, 2019, and 2020. I mean, all retroactive. So what was Mr. Ramsaran's chance? How would the regulations have been applied? How on earth would, I mean, the whole regulation, the regulations contemplate that you would make a recommendation and give people 7 days to make representations. Well, you completely destroy and eliminate that if you're going to do it in this manner. So, I mean, and then they say, well, we inform you that it's not a prelude to a permanent appointment and it gives you no claim to promotion. Well, that's not the point, is it?
I'm sorry, Mr. Ramlo. What exactly is the point that you're making on this letter that assists your appeal?
The point I'm making is it's manifestly unfair. It reeks of arbitrariness and inequality, because you have completely frustrated my client's rights under the regulations to be notified of an acting that you're going to make an acting appointment before you do it. You don't obviously give it the opportunity to be considered by the Commission because you're doing this retroactively. And my Lord's point, the burning question is, well, on what basis was this retroactive appointment done? Was he performing those duties, and on whose authority?
My understanding is that, take for instance the 1st of January 2020 to the 30th of June 2020, that is there is a requirement in Regulation 155(1) to notify all eligible fire officers of that potential for them to apply.
Yes.
And there was no notification.
None. Absolutely.
And then there's a requirement also that you have to, the chief fire officer has to submit his recommendation no later than 28 days preceding the date on which the acting appointment is intended to become effective.
Yes. My Lord, the regulations were they intended to be operate in a prospective manner, not, everything was to be done in advance and real time. This here destroys and turns it on its head. And what it does, it allows for what we locally call curry favoring. It allows you, if you have a blue-eyed boy, you can allow them to perform the duties, and then you approach the Commission and get everything retroactively done, thereby eliminating any competition they would have had. It's a complete loss of the opportunity and the chance to be considered. And this here is at the heart of our complaint. And you will see the time periods. Now, my lords, and we will note as well that it crosses over even after our client completed the course, because he completed that course in August 2019. And the last two of these appointments come after he would have completed that course, but yet still he would be deprived of the opportunity to be considered or make representations on his behalf because of the way they operated the regulations in a very inverse manner. It's not just that course. I mean, bear in mind, Mr. Ramsaran also completed his master's, in occupational health and safety, has an associate degree from the Cipriani Labour College. It's a long list. The man has always been trying to better himself. Can I go to page 763? At 763, you will see Mr. Ramsaran on the 1st of December 2019. He writes to complain about being bypassed. And he says, he lists all the courses he's completed. He's completed the Fire Service College in Morton in Marsh, England. He has a senior management post, and he lists, he says he's been promoted to the Divisional Fire Officer on the 4th of February 2016, and he's been acting Chief Fire Officer since 14th of March 2016, and he lists all the qualifications that he has. I mean, this man is of stellar quality, and he ends by saying the person who is acting, he said, I'm of the view that I've been overlooked, and the person who is acting in the post of Deputy Chief Officer, Mr. Lane, he's junior to me. His name appears at number 7, and I'm number 3 on the list of promoted divisional fire officers.
Can I just check? Do we have the memo dated the 10th of June?
The 10th
of June 2019 that's referred to at the top of 763?
Yeah.
I think it's the one we saw earlier. But,
yes. I think it's the general order with the...
no, that was a different one.
Yeah.
The one we saw earlier was the 23rd of May.
Yes.
Yeah, my lord, I think that's an error on the part of Mr. Ramsaran when he crafted the letter. I think the correct date of reference is 23rd of May, 2019. I think that's
that's the slip for the 23rd of May, is it? Hmm.
Yes, I think so, my lord. I think so. That's the way.
Is one of the points, it's the Public Service Commission that is meant to make these appointments, is that right?
Of course, yes.
And all that in fact happened was that he got a memo from the Chief Fire Officer, which didn't actually show, as one of your complaints, that it actually ever been considered by the Commission at all.
Indeed.
In fact, it appears it hadn't been, because they never got to consider it until they retrospectively considered it the next year.
That's correct. That's correct. I mean, Lord, the evidence shows that, contrary to what the Constitution intended, you have this, this ongoing discussion between the Ministry of National Security and the chief and the chief fire officer. I mean, the commission comes in almost, after the fact as a footnote.
So instead of these appointments being made by the Public Service Commission as intended and the statute requires, they're actually being made by the Chief Fire Officer himself, without any process, without any interview, just what he thinks, who he thinks he wants to appoint, and then afterwards he gets the Commission to approve it all after it's happened, when there was never any competition properly at the time at all.
Well, that is the inescapable and irresistible conclusion and inference on the evidence from the statement, Lord, because that is precisely what the chronology of events reveal. The commission was really reduced to the status of a mere rubber stamp in these matters, my lord.
And was that the complaint below? It's probably my fault, but I'm not sure that I'd picked up that was the complaint that you were running below.
My lord, the complaint is that they devised a system that was outwit the regulatory framework that was being administered in an arbitrary and capricious manner without reference to the regulations and the rule of law. That's the complaint.
Yes. And so can you just show me where you say that the Commission didn't take the relevant decision in your pleading?
Well, my lord, can I seek the assistance of my junior and come back to that, my lord?
Certainly, yeah. But if you could do so before you finish your submissions.
Part of the problem in this case is the wood hasn't been distinguished from the trees, it seems to me. It's taking a long time to distill from the myriad of complaints the fairly fundamental complaint that there really seems to be.
And there's an obligation, of course, on the Commission and also the Chief Fire Officer to assist the court and to disclose what it did do and didn't do. And
well, our submission in relation to that is that we can't unfairly penalize the appellant in this situation, because, Lord, when you make a serious complaint and you put forward a prima facie case, the law is that the evidential burden shifts onto the state to justify and explain to the court and the appellant, you know, in a full and frank manner, well, what happened and why. And that the reason I find myself in all these intellectual evidential gymnastics is because the evidence simply isn't there. They did not discharge their duty to make full and frank disclosure, and the evidential burden just remains unsatisfied. And
right, but I think Lord Leggett has identified a possible way in which you might have put your case, even on these materials. My question is, did you put your case in that way?
Well, my Lord, we say yes, we did, my Lord.
Yes, and I've asked you for the references, so hopefully you're going to provide them.
Yes, my Lord. As I indicated, my juniors combing through the pleading, and I will come to it, my Lord, before I finish, my Lord, as I promised.
Could you just help me with one matter? If you go to page 873, there is a memo from the Chief Fire Officer to the Permanent Secretary, Ministry of National Security. Now, this is a document which has been referred to on a number of occasions, and it's the document in which the Chief Fire Officer says that the appellant now complies. He is eligible for consideration. What I fail to understand at the moment is, why is he writing to the Permanent Secretary of the Ministry of National Security? What role is that? What function is being performed there?
Well,
What have they got to do with this appointment process?
well, Lord, nothing, because the whole point in the regulatory framework and the Constitution is to insulate the appointment and promotion process from political involvement and interference. And that's why I mentioned the ongoing dialogue and discussion between the ministry and the chief fire officer is a matter for concern. I mean, this is a document that came from the chief fire officer.
Do we have the memorandum to which it's a reply?
No. That was not disclosed.
6th of January 2020. No, I don't.
No.
Presumably somebody contacted the Permanent Secretary who was expressing some concern about what was happening, and this was, seems to be a reply to try and reassure him.
Yes. But, my Lord, we compile, in the Court of Appeal, we compile a menu list of all the documents that were not disclosed, that are mentioned in the evidence for the state, that are not disclosed. You know, but that's why we say the evidence is really lacking in a serious way. Can I take you to page 820, please, my Lord?
Page 8.
820.
Thank you.
And you will see, we're told in paragraph 5, Mr. Lane was positioned at number 3 on the order of merit list for promotion. Based on this, Mr. Lane acted as DCFO in the past ahead of other senior DFOs. Now, again...
I'm sorry, can I just check what this document is?
So, oh, sorry, my Lord, I beg your pardon. It's again a response to the pre-action protocol letter.
Okay.
And my Lord, but the point I'm making here is they're not applying the regulations. The regulations don't even... They're using this merit list, which we say he should never have been on, and that's the basis on which they're making the acting appointment. And then they say he was given consideration to act as DCFO by virtue of his qualification initially, and thereafter by his previous experience in the position and the length of time he held services, based on representations by various officers to the current acting chief fire officer and to the permanent secretary. The ministry has sought guidance from the Service Commission's department on the acting arrangements for the rank of DCFO, notwithstanding previous submissions and recommendations it may have made. As of this date, a response is still being awaited from the Service Commission's department.
Just so we can understand this letter, can you give us the bundle reference to the letter that's being responded to at point 5. They say the statement at instruction 12 of your letter is true. Can you just help
It's
us?
a response to my letter of June 1st, 2020.
Which is,
Yes, my lord, I'll get that page reference to you now. June.
So is this a justification given for why Mr. Lane was given the job initially?
Yes. What page? It's at page 7, 9. $791, my lord. 791.
Thank you very much.
791. And then I take you next to page 735. And 735 is a memorandum. It's dated September 25th, 2000. And it governs acting appointments in the fire service. And it says, in addition to regulations 154 and 158, the fire service shall, and this is put out by the chief fire officer, it says that the director of personnel administration has advised that acting appointments shall be in accordance with the following criteria. Order of merit list shall be used as a guide in selecting officers for acting appointment, which are as a prelude to promotion to the substantive rank. And I just showed you the evidence where they were using the merit list to make appointments, acting appointments, that were not a prelude to a substantive appointment. And this here tells us that the order of merit list was only going to be used as a guide for acting appointments, which are a prelude to substantive appointment, which is promotion to the substantive rank. And then they say, where no order of merit list exists, acting appointment shall be based on seniority in the present rank, satisfying the requirements for the next rank. Well, all of this is devising their own procedure outwith the regulatory framework without bothering to have any amendment to the regulations. They have devised their own process. This is signed by the chief fire officer. So when we complain about the arbitrariness and the unfairness, this is the evidence. It's all pervasive. And then we go next to page 961. And you will see at page 961 at the bottom of the page, no, sorry, it's 962, I beg your pardon. We've been at 962, the third paragraph. The recommendation for the acting appointment of Mr.
Sorry,
Irvin Lane,
which page? Sorry?
962.
962, thank you.
962. 962, the recommendation for the acting appointment, third paragraph. The recommendation for the acting appointment of Mr. Mervyn Lane for the office of DCO for the period June to December 2019. He was in possession of the Brigade Command course as of 2013 and had gained 5.5 years at a senior managerial administrative level. The requirement was 6 years. So this is on their own evidence, an important concession that he did not, in fact, as of 2019, he did not, in fact, satisfy the 6-year managerial requirement. And if he didn't satisfy that, and that was a mandatory requirement alongside the educational, the course requirement, well, then why was he being considered, and why was Mr. Ramsaran not being considered? That's the question. Now, my lord, part of the one of the problems that crops up in can I take you to page 850 to briefly go to?
sorry, can you give us that page number again, Mr. Ramlogan?
I'm sorry, my lord. Which one was it? The last one, my lord?
The one that you just gave us, yes.
961.
850, I think it was.
Oh, sorry, 850, beg your pardon. Well, if I can take you now to the affidavit of Mr. Marlon Smith, the then acting chief fire officer. It begins at page 847. And you will see at paragraph 8, it says Mr. Lane acted as assistant chief fire officer. And I'm on page 848 for periods outlined while in the substantive office of assistant divisional fire officer. And he says, whilst they acted as deputy chief fire officer for the periods 2016 and 2017, based on a 2015 order of merit list. That is the evidence. He didn't act based on the holistic assessment of an application of the statutory criteria. He was appointed to act based on his position on the 2015 order of merit list.
Well, he wasn't actually appointed. What happened was he was just put in place.
Well, indeed. And then we go to...
That's why they say recommended.
yes.
We haven't actually seen any evidence that there was any recommendation until after the event.
Yes. Well, can I then go to paragraph 20? We'll see in paragraph 20, paragraph 19, sorry, beg your pardon, it's paragraph 24, my lord, that at page 851, he says he doesn't agree that the claimant is entitled to be appointed to act as DCFO upon completion of the International Brigade course because he still doesn't have the requisite management experience. Mr. Bristow, who is senior to the claimant, is also in possession of the International Brigade Command course. Now, my lord, they kept shifting the goalposts on the appellant. All the time you're saying, well, look, you didn't have the course. Nobody mentions anything about the experience requirement. When he gets the course, then they shift the goalposts and say, well, you don't have the experience requirement now. And that experience requirement is a highly contentious matter, given the way that the evidence has unfolded. If I take you to paragraph 35 at page 852, you'll see at paragraph 35, we say, where a number of senior officers are without the necessary qualification, that being the brigade command course, the quality of the appointment may be affected by the limited experience of the officers as one goes down the seniority list. The acting appointment may go to the most senior person. Officers are given acting appointments with priority being given to their specific qualification for the rank over seniority alone. When promotions follow such arrangements, the officers qualified for promotion are the ones promoted. It is also customary for persons to act, although not qualified, provided that there are no suitably qualified persons to hold that office. Therefore, in the absence of persons deemed to be qualified for a given rank, the next senior person are so considered. Now, that's why I started with the divisional fire officer position with our client being senior to Mr. Lane. Because if the evidence is that they use seniority to make the acting appointments, well, why wasn't it done in the case of Mr. Ramsaran? And then I take you next to page 885, Mr. Corey Harrison. And I take you to paragraph 6. In paragraph 6, they said when the claimant started acting as ACFO, he did not satisfy the requirement for the office as outlined in the job description, as he was not in possession of the requisite training divisional command course, nor the 5 years experience at the managerial level. Well, if that is so, it meant that the holistic approach would have obviously, because one has to apply a presumption of regularity, surely the holistic approach would have given him the edge over his competitors, and that's why that was possible. Then we're told in paragraph 7, the claimant was appointed to act as a CFO based on his position on the seniority list.
I'm so sorry. On paragraph 6, why is the reference to 5 years' experience? Is that?
That is
That was an earlier job specification.
Right, that's what I wanted.
And
Yes.
he didn't have it, but yet he was appointed. Is that the point you're making?
indeed, yes. And I'm saying that the only way that can happen is if
Well-
you would have applied the holistic approach in terms of the range of criteria. But it also shows why the guillotine approach of saying you either have this or else out you go is simply not right on their own evidence, even though they don't condescend to give particulars about why this occurred and how.
Could you, there's a reference to CH1. What page is that at?
CH1 is it's the organized, just 1 second, Mark. $897 million.
And so this had at page 898 at least 5 years at the level of divisional fire officer.
That's correct. And my lord, you'd notice that this.
And did he have that 5 years experience?
I thought
Yes,
he
Lord.
didn't. Sorry, I
didn't,
thought we were
yes,
just
yes,
looking
he
that he
didn't.
didn't have it.
Yeah,
but
he didn't have
appointed
it.
nonetheless.
Yeah, he didn't have it, and yet he was considered. Is that right?
Yes, that's correct. That's correct.
Okay. Okay.
And my lords, can I?
And sorry, you wanted to show us another paragraph in Mr. Harrison's affidavit. We've looked at paragraph 6. Which was the other one that you wanted to show us?
Please, my lord. Let's try it. My lord, if I can take you to page 983, yes, my lord, 983.
Right, so I'm just checking. There was nothing else in Mr. Harrison's affidavit you wanted to show us?
Not at this stage, my lord, no.
No,
Page
all
9, at page 983,
Yes.
you will see that in 2010, you will see that the office of the chief personnel officer was approached for advice, and in relation to the chief fire officer. And you will see at paragraph 2, the chief personnel officer says, I had indicated that in light of the dearth of suitably qualified officers in the fire service.
Well, so Mr. Ramno, why are we looking at this? This seems dated much earlier, 12th of February 2010.
It is, my lord. I only draw it to your attention, my lord, because even in a case where the officer did not satisfy the mandatory educational requirements, they were able to, they took it upon themselves to waive it by seeking a waiver from the chief personnel officer. That's the only reason I highlighted, my lord. But again,
Right, but I don't believe the appellant did ask for waiver in his application.
No.
All right, so
That's
this
correct.
doesn't seem to be very helpful, this particular document.
My lord, the point I wanted to make is, if he had, my lord, okay, I'll press on, my lord. I hear you. Can I go next to page 889, please, my lord? 889 at the bottom of the page. This is the affidavit of Mr. Corey Harrison. And at page 889, at the very bottom of the page, my lord, you have paragraph 20. He says the claimant was not in possession of the required brigade command course or its equivalent as at March 18, 2019. The relevant management / administrative experience is considered when a fire officer is performing in the offices of assistant chief fire officer and higher. And I'll ask you to stick a pin there. Mr. Harrison is saying that the office that allows the experience to count is some ACFO, Assistant Chief Fire Officer, and above. Now, Assistant Chief Fire Officer is above that of Divisional Fire Officer. That is what he says there, Assistant Chief Fire Officer and above. Can I then take you to page 1200?
I'm sorry, can you just explain to me the significance of the point you were making on paragraph 20?
The significance is when I take you to his later affidavit, you will see he moves the goalpost in terms of when, from what rank does the experience count.
Right, okay.
And if he applied that criteria, would the appellant have 6 years experience?
My lord, if he applied not the ACFO,
No.
but if he applied the ADFO,
If he applied what, sorry?
Assistant Divisional Fire Officer.
So I think looking at the point being made in paragraph 20, I don't think the appellant would have been able to satisfy 6 years acting as ACFO.
No.
No.
But
Right.
neither would Mr. Lane.
So you're going to show us where you say that a different criterion is being used by Mr. Harrison.
Indeed, my lord. I apologize. It's page 1200.
Page 1200.
Yep. This is a later affidavit that came after there was some wrangling between the parties, and you'll see at paragraph 7. This is Mr. Corey Harrison's affidavit again. It begins at page 1198. And at paragraph 7, he says, further thereto, where the job description and the said letter refer to senior managerial administrative level experience, the commission considers that same is obtained when a person is performing in the functions of divisional fire officer and officers senior thereto. So in the one hand, in the first instance, he said, Assistant Chief Fire Officer and above. Now he's saying Divisional Fire Officer and above.
But your basic case is all these requirements were made up after the event.
Indeed.
Because if you look at the chronology, I mean, what strikes me, though you haven't emphasised it, is that the advertisement for the post that Mr. Ramsaran applied for, that we saw with a station notice, was in the 6th of May, I think, 2019, wasn't it? But the decision to appoint Mr. Lane, or to recommend him, because there never was an appointment, had already been made in March.
Yes.
And in that memorandum in March, it didn't say anything about, they even thought about your client. They just said, Mr. Lane is a jolly good person and we're going to recommend him. And then they held the advertisement afterwards, and then they produced one reason after another to justify why they'd never considered the appellant. But actually, they never, the recommendation had been made in March.
It was a fait accompli. And what they've engaged in is ex post facto justification. They're cutting their cloth to suit it after the fact. But really and truly,
I mean, Mr. Smith, in his affidavit, you showed us paragraph 8, I think, says that they took the decision in, he refers to the memorandum incorporating the recommendation, and that was the memorandum you showed us dated March.
Yes.
The page of the memorandum, I think...
866, is it?
Yeah, 866, that's right. 866, so that was that was when they actually took the decision. And at that stage, they haven't advertised the post. They hadn't considered anybody, except on this little internal memo.
That is correct, my lord. That's correct. But, can I just take us to page...
And then they only ever did consider, I mean, it was never appointed, it was just this recommendation, and that was Mr. Lane acting for the next couple of years, and until they get it signed off by the Commission after the event.
A year later.
A year later.
Yes.
And why is that on the 18th of March memorandum, it's again to the Permanent Secretary of the Ministry of National Security,
My Lord,
the role of which I yet don't understand.
no, because my Lord, it contaminates the insulation mechanism that the Constitution devised by having the Service Commission as an independent body to make these, to exercise what is a sole and exclusive jurisdiction to make promotions in the fire service.
So there was simply no proper process whatever. They just selected Mr. Lane, put him in place, sent out a notice, but when they got an application from Mr. Ramsaran, he was just given one excuse and then another one when the first one it couldn't work anymore.
Well, it seemed that they were essentially covering the tracks. That's what this is about. But can I take you to
Mr. Ramsaran, just so you know, you've got 10 more minutes with quite a lot to cover if you want to cover your constitutional complaint and if you want to cover what happened after the 19th of August 2019.
My Lord, I do. Can I take you to page 489, please, my Lord, quickly on that score? My Lord, in our affidavit, we had identified comparators in support of our case of inequality of treatment and arbitrariness. And my Lord, we said, I mean, Mr. Ramsaran has been in the service for 40 years. The man knows his colleagues, and he identified all those who had been appointed to act and promoted without having this course that so much song and dance has been made about. And the evidence in response is so wishy-washy and evasive that this is the table from our Court of Appeal submissions, but essentially we've compiled it into the IBCC course and the requisite 6 years experience. Mr. Ramsaran, he didn't have the course, didn't have the experience, they say. Mr. Mervyn Lane, yes.
Sorry, which page are you reading from?
Page 489, my Lord, 489.
Yes, thank you.
So you'll see that Mr. Ramsaran, Mr. Lane had the course, but he didn't have the experience. Carl Williams, he didn't have the course, and we say it's unclear whether he has the experience because the response of the commission to this direct evidence from the appellant just they don't condescend to give any particulars whatsoever. And that's the case for all of the other comparators. So when we identified persons, and Mr. Ramsaran said, well, how could you be making such a huge song and dance about this course when I'm concerned? But all of these other persons, you had no difficulty appointing them and promoting them even in some cases. And they didn't have the course. And instead, the commission, in its evidence and response, it sidesteps, it prevaricates and vacillates, but it doesn't answer it at all to say, well, they either had it, they didn't have it, and if they didn't have it, this is why we appointed them. Nothing. And my Lord, the law is in equality of treatment cases. Once you've set up a prima facie case, the evidential burden shifts onto the state, who must now justify and explain what transpired and explain it to the court. And they've failed to do that. And when they fail to do that, my Lord, the adverse inferences must be drawn against the state and in favor of the appellant on this matter. And we say the comparators that we've set up for the state to answer to, they have failed miserably, and they're the only ones who can provide that explanation. Can I, in the remaining time now, my Lord, just go quickly to the pleaded case, my Lord, because I know my Lord Sales has asked me that about this repeatedly. And my Lord, if I can take it on page 83.
83.
83, yes, my Lord. You will see we say the bypass for acting appointment after August 2019, and you will see we say that this is a challenge to the decision to continuously bypass the claimant for acting appointments in the office of Deputy Chief Fire Officer, and the failure to reconsider that decision. His case is that he ought to have been appointed to act as Deputy Chief Fire Officer in the vacancy that was created when Mr. Roosevelt Bruce proceeded on pre-retirement leave on the 18th of March 2019 and thereafter, because, and we say acting appointments usually, and the evidence bears that out from them, was done based on seniority, and he was the most senior person in line. They've bypassed him for the said acting appointment in favor of Mr. Lane, who was junior to him.
Well, sorry, just on that first point, that seems to be inconsistent with the case that you've been presenting to us on Regulation 1581, about it being a holistic assessment. I just want to check that that particular case is inconsistent with the submission that you're now making to us.
No, my lord, at the time, the instructions I received and the evidence was that in conducting that holistic assessment, it would appear that greater weight was paid not to the educational qualifications, but more so the relevant experience of the officer, and that is what we mean by seniority. So, my lord, that was our case. The client was saying, look, I should have been appointed to act because I'm the most senior divisional fire officer, and I'm definitely senior to Mr. Lane, so I should be the one who would be appointed to act.
Well,
now,
I think there's a world of a difference between seniority and experience.
Well, my lord, that's the way they interpret it and apply it, and you will see when you look at the affidavit evidence filed on behalf of the respondent, that is how they, in fact, hammer it out in their own evidence as well.
At all events, you were showing us your pleaded case, so please continue with that.
Yes, look, if I go over, we said he's been unfairly excluded from consideration. I'm on C now, on page 84. Unfairly excluded from consideration for acting appointment on the basis that he did not possess the IVCC and did not satisfy the requirement. He was hence disqualified and illegally excluded from consideration because he was wrongly deemed to be ineligible. And we say his exclusion was irrational and unfair because although he did not complete the course, Mr. Lane did not possess the 6 years managerial experience and was therefore similarly disqualified, in consequence of which the claimant, as the relatively senior officer, ought to have been appointed to act. This is in accordance with the policy whereby, in the absence of persons who are qualified for the higher rank, the next most senior officer will be appointed, and that's a quote from their own evidence. And then if I take you to F at the bottom of the page, you will see in bypassing the claimant, the chief fire officer deliberately and willfully breached Regulation 155 by failing to notify him of the proposed acting appointment and invite him to make representations to forward to the Public Service Commission. And if we turn the page over to the next bit in red, we say he favorably considered Lane, even though he didn't have the six-year experience. Lane was recommended for retroactive acting appointments without informing the claimant, far less allowing him to make representations on his own behalf in accordance with Regulation 155. So we specifically, and in H and I, we say the Commission acted unlawfully in accepting and or relying upon the illegal recommendation of Mr. Lane to make the acting appointment, which became the fruit of a poison tree because the mandatory procedure prescribed by the regulations was not followed. Furthermore, the Commission acted unfairly because it knew or ought to have known that the claimant was the most senior and qualified candidate, and he should have been invited to make representations before the Commission took a decision to bypass him and appoint his junior instead of him. And this was necessary because the claimant had been acting in the office of Assistant Chief Fire Officer for 4 years and would have acquired relevant knowledge and experience. And then I turn now the page to page 86. Bypassed prior to August 2019. We say the claimant does not accept that he must have been qualified in order, i.e. for promotion or substantive appointment, in order to be eligible to be considered for acting appointment in the higher rank or temporary acting appointment, which is not a prelude to a substantive appointment. In that case, it should be, at the time we said it should be based on seniority. And we say Mr. Officer Lane was not qualified because he didn't possess a 6-year requirement. And we say that even if temporary acting appointments were based on the order of merit list, it could only be based on a valid and proper merit list compiled in accordance with the principles of natural justice and the right to equality of treatment.
Yes,
And it was compared,
Mr. Ramlogan, thank you for drawing our attention to that. I should mention that you're almost at the limit of your time. You can continue, but you will be eating into your reply time. But I'm conscious that you haven't expanded on your submissions about what happened after August 2019, and you haven't developed your case on breach of the Constitution. Is there anything you wanted to say briefly about those two things?
Yes, my lord, can I go to page 87, where we set out the constitutional case on the breach of the right of protection of the law?
Yes, just before we get there, was there anything additional you wanted to say about the situation after August 2019? Or have you sufficiently covered your case?
My lord, I think we've covered it in the pleaded grounds, my lord, and I rely on the pleaded case.
All right.
And I rely also on the totality of the evidence in this matter. My lord, in terms of breach of right of protection of the law, we say that in ground 8, we say that the policy, practice, and procedure for making temporary acting appointments is vague, unclear, and uncertain. It lacks transparency and certainty and provides fertile soil for arbitrariness and capriciousness in the exercise of administrative discretion by the chief officer and the commission. We say the defendants have failed to provide any clear answer or policy document which sheds light on this important matter. The response from the state has caused confusion and intensified the ambiguity that surrounds this important issue. The lack of certainty is easy to discern when one compares what obtained before under the Public Service Commission regulations. The claimant has a right and is entitled to a process that is transparent, certain, and fair, and the action and the conduct of the defendants have breached that right. The claimant has tried to ascertain what is the policy and procedure via applications under the Freedom of Information Act to no avail. The absence of a clear policy and procedure has led to arbitrariness in the procedure and policy for making temporary acting appointments that are not made as a prelude to substantive appointments, in consequence of which his right to protection of the law has been breached. And then in paragraph 12, we say that this was, we complain about the shifting of the goalpost. And then I come now to, quickly, my lord, to the page 95, paragraph 3.0. You'll see the recommendations made by the CFO in favor of Mr. Lane were unfair and irrational because it did not inform the commission that Mr. Lane was not qualified because he didn't possess the requisite 6 years. It did not indicate that in the absence of any other suitably qualified person that the claimant was in fact the next most senior officer, and it did not contain the reasons for bypassing the claimant. We say the procedure and policy was constantly adjusted and changed to deny the claimant the opportunity to be considered for the said acting appointment in favor of Lane. And see further particulars below in our grounds in the claim for breach of the right to equality of treatment. And Lord, that you will see now in terms of the right to equality of treatment point. You will see that we've set out a paragraph in great detail, our comparators at paragraph 6 on page 99. And we've pleaded that the following persons were treated differently as compared to the claimant because they were previously allowed to act without having a brigade command course and without having the requisite 6 years experience. And we've listed them, we've put the station order, and we've put the dates when they acted, and we have detailed why we have said that these comparators, we are similarly circumstanced to them because we too, if they wanted to say at the material time, did not have the course, but we are showing by evidence that the commission over the years has in fact appointed persons who did not have the course or the experience, or in some cases, neither. And we say, if you could treat them that way by reference to the holistic assessment or however, whatever discretionary power and jurisdiction you exercise, we say that you have treated us unequally. You have not treated us, we have been treated differently even though we are similarly circumstanced and there is no lawful justification or explanation for the difference in treatment meted out to us, notwithstanding our similarity in circumstance. So that is the case on the inequality of treatment, and we say they failed to discharge the evidential burden that shifted onto them to give a proper, cogent, clear, and compelling explanation for these matters that we raise in terms of the differential treatment meted out to the appellant as compared to these the identified comparators. My lords, those are my submissions on behalf of the appellant.
Yes, thank you very much, Mr. Ramlogan. You used up 5 minutes of your reply time, but that still leaves you plenty of time for reply, I think, in due course.
I'm obliged to you, my lord.
So, Mr. Pennington-Benton.
Well, thank you very much, my lords. I just start. I must make an apology to my Lord Stevens, because
Oh, don't worry about it.
I got overexcited.
So do I guess.
Yeah. Thank you very much. My lords, I am here to assist in what I think is a very difficult case factually. It's quite difficult to figure out what went on at different stages, and there's lots of bits of law and polity in different places. And I am here to assist as much as I can in that process. During the course of that process, I may as well say at the outset that I do accept that things obviously didn't go as they should have gone. I mean, the point made forcefully by my Lord Legate in terms of the retrospective appointments.
Well, as I said at the moment, I mean, all sorts of dust has been kicked up, but the substance of it is that a decision was taken, called a recommendation in March 2019, simply to appoint Mr. Lane without any consideration of other candidates, any process, any involvement of the Commission, whatever. There was then, in May, an advertisement put out for an application, so Mr. Ramsaran duly put in an application, but he was, so far as we can see, without any involvement from the Commission, simply told he didn't qualify because he hadn't done the course. He then did the course, nothing else happens, and then about a year on, the Commission simply rubber stamp everything that's taken place with still no process or consideration of candidates. So, I mean, we didn't get into, as I say, all these details. Just the substantial point is there was never any process or consideration at all.
Well,
simple as that.
Well, in terms of the retrospective operations of the Commission, I think we would say there's no pleaded case on that, and that was never really the point that was taken below. And of course, certainly it doesn't excuse all of the period, but from I think February 2020 until June 2020, the Commission was completely locked down, as most of Trinidad was. So it's not as if there was nothing that could be said about the reason why things were being done out of order, although, to be fair, in 2019 it's difficult to understand why there was a lag. But I don't accept respectfully that there was no process. I can see my Lord's points, but I do think there were recommendations. There's a problem with the timing.
But well, the recommendation, I mean, who were they made to? They weren't even made to the Commission, as far as I could see.
The process is, well, they are.
Or does it go via
Yes.
the security office?
Well, it goes to the DPA, it goes to the Director of the Personnel Administration, to the Commission. So that's the process of communication. That's just how it works. And it's copied into the Ministry because the fire service is within the Ministry. There's nothing unusual. I've always
need to speak up so Mr. Ramlogan can hear.
I'm so sorry. Can you not hear me? Yes, so that's the process. That's always been the process.
That's where the recommendation is made in March, which Mr. Smith says was the recommendation for the job.
Well, it's not
that
quite,
goes to the Ministry of National Security, but that is meant to go onward, is it, to the Commission? There's no evidence they ever went to the Commission.
Well, it's actually a bit more complicated than that because there's that initial recommendation. Then, as far as I can see, as I understood it, that had actually been taken over by the fact that they then advertised the post. And then there is a second recommendation.
And
When's the second recommendation?
Second recommendation. So the refusal to consider Mr. Ramsaran is in May.
Yes.
And then, bear with me, It's in January 2020. I know that's the date. Let me just find the reference for it.
And what?
So there's a recommendation then in January 2020.
Correct. Yes.
The Court of Appeal.
So after he'd been told he was shut out in May with no further consideration.
Correct.
Then beyond the recommendation already been made in March.
So you have the recommendation in March. As far as I can see, that falls away because then there's just an advertisement for the post.
No, it doesn't fall away because Mr. Smith says that was the recommendation and it was on that basis that he acted in the post at page 848.
Well, that's not the... Yes, unfortunately, that's not what Mr. Harrison says. So
Well, Mr. Smith should know because he made the recommendation.
Mr. Smith didn't make it, it was his predecessor.
Oh, right.
And it was Mr.
Oh, he was one of the recommended people, wasn't he?
And then Mr. Harrison, who is the DPA, the Director of Personnel Administration for the Commission, gives evidence that at paragraph 16 of his affidavit, which is 888.
888.
These are the relevant recommendations, actually. That's on the 2nd of January 2020 is the one that recommends Mr. Lane for the post, effectively.
Sorry, we're
So paragraph 16 at the very top. 20, there's two recommendations. One's on the 29th of August, which does not concern Mr. Lane. And then there's one on the 2nd of January, which does concern Mr. Lane. Those
2nd of January.
2020, correct, yes. And then those, we can see those at CH4, which is best place to start is at 920.
Thank you.
So 920 is the January 2020 recommendation. And then if one turns to 920...
Just before we go on.
Yes.
Let's have a look at some of that.
Sure.
Which is the relevant part of it?
So it's the relevant part on 920. So it's from the Chief Fire
Hard to read, but I'm trying to...
Officer to the Permanent Secretary.
Approval is hereby sought for officers in the whatever to...
First Division, the First Service Division, Ministry of National Security, who act as Chief Fire Officer and DCFO. The recommendations are made in accordance with...
That can't be so because they're not made before the appointments are made. And they're not made within 28 days prior to the office becoming vacant.
Well, the recommendation is made, as your Lordship rightly says, after effectively it would appear Mr. Lane has already assumed the role, yes.
And with no process or consideration of candidates or anything, apparently, just this is all we have, is it?
Well, there's what should happen is there is a recommendation, and then although no time limit is stipulated in the regulations, then obviously the natural flow of things is that Commission will make a timely decision. There's nothing in the regulations that imposes a time limit on the Commission, but yes.
There's a recommendation that has to be made in 28 days prior to the office becoming vacant.
And that's what the judge says was breached in this case.
And it was breached.
Oh, yes.
Yeah.
Yes.
And whereabouts in this document do we find references to Mr. Lane?
So if we then move on to 923, that's the appointments in respect of which the recommendation is made. So it's from...
Mr. Lane, right. I see.
Yes. And that's why I say the first recommendation falls away, because it's this one really that matters.
So his performance appraisals are being processed. Very good. And that's it, is it?
Yes, so these are the recommendations.
So the recommendation to the Commission,
correct.
the information they're provided is that he's very good, and how about their consideration then of the various factors in Regulation 158?
Well, that in the respondent's case below was that Mr. Lane was the only person who met the job specification.
So they didn't. So they didn't give any consideration at all to Mr. Lane's abilities under Regulation 158. Let's have a look at Regulation 158 again.
Well, I don't know what additional, he doesn't state what additional, because he hasn't given his reasons for his decision, but the reason why only Mr. Lane was recommended is because he's the only person that met the job specification.
So where are you getting that from? Is that in the affidavit or in the document?
Yes, it is in the affidavit. I'll just try and remember where it is, but I find, well, it's more of an inference from paragraph 18. I think I have seen it somewhere else, I think more definitely, but it's in paragraph 18 of Mr. Harrison's affidavit at 888, where he recognises that Mr. Lane's appointment, well, he's actually recounting there the meeting of the Commission in April 2020, and he recounts that other officers weren't appointed since they did not satisfy the training requirements and did not have the requisite experience. So I infer from that Mr. Lane, in other words, was the only person that did. But I think also I've seen it said more definitely elsewhere, but I can't, I'm afraid. But,
All right, well, perhaps you can check that over.
yes, I'll check that. But anyway, certainly I would infer it in any event from paragraph 18. That's the officers that could have applied or could have been appointed didn't have these requirements, and he did.
And does that exonerate the Commission from their obligation to take into account the experience, educational qualifications, etc., etc.?
Yes, I think that has to be, yes, we'd say that the job specification entitles, or to put it the other way around, the fire service is entitled, in consultation with the Ministry, to create a job specification that imposes certain minimal requirements, notwithstanding the breadth of the considerations in 158, yes. But can I...
But when it comes to the Commission actually appointing Mr. Lane,
yes,
retrospectively, are they exonerated from their obligation to take into account various things? And they can just say, well, he's the last man standing.
I say yes if I'm right on the first point. In other words, if the fire service is entitled to create a job specification, then it follows that the Commission is entitled, because the Commission will only consider people who are recommended. And if the CFO is entitled to only recommend someone who passes the minimum requirements that the fire service thinks are necessary for the role, then it follows, yes, that the Commission will only consider the recommendees. There's a lot, I appreciate, and I'm getting sucked into the substance, and I appreciate there's a lot of ground to cover, and I'm trying desperately to think of ways to make it happen quicker. But I'm not sure in the end I'm going to succeed. But I did want to say at the outset, I accept things went wrong. I don't accept this is necessarily how the case was pleaded below. I don't accept, for example, that the ultra vires or fettering of discretion, however one characterises the job specification argument, was actually made below. So there's a reason why I don't have chapter and verse instructions on who makes the job specification. I'll have to come back to the moment. Anyway, but I do appreciate that things went wrong, and I do appreciate that there were breaches of the regulations, no doubt about that. But what I do need to try and do, there's also some thorny bits of law in this that we do respectfully have some important things to say on. Could I just, in the 5 minutes that I've got left, and I apologise if this is going over old ground, but just clarify what actually is the law and the policy that applies to the appointments, or that we say applies to the appointments. So let's just go, if we may, to the regulations. They start at 1663. Just looking at the contents page, turning on to 1664, one sees Regulation 26. Regulation 26 deals with acting appointments not as a prelude to a permanent appointment. That appears within Chapter 3. chapters 3 to 6, as my learned friend Mr. Ramlogan rightly says, are all removed by Regulation 2A. The Regulation 2A is at 1672, 1672. So those don't apply, but that's primarily the way that the case at first instance was argued. It was the repeated references to seniority are repeated references to Regulation 26, because 26, when it applies, basically says that acting appointments, where there is not a prospect of a permanent appointment, so a temporary acting appointment, someone's on holiday, can you come and fill in for a few weeks, were just dealt with on the basis of seniority, because that's a quick, fast way of appointing someone for a short period of time. Makes sense. But that doesn't apply in this case. Whereas
Because it was cut out.
Because it was cut out. Yeah. But that's why there's repeated references in the pleadings to seniority as being the overarching requirement. But once that goes, it isn't the overarching requirement. So next, we go to 154 to 154 to 160. So 154 is important. That's the chief officer shall ensure that recommendations made in relation to acting appointments.
Sorry, is this Regulation 154?
Yes, indeed, my lord. Regulation.
What page is that?
Oh, I'm so sorry. 1722. 1722 at the top. So subject to Regulation 157, the Chief Fire Officer shall ensure that recommendations made in relation to acting appointments are based on the criteria prescribed in Regulation 158, accepting that they're not actually criteria, they're factors or desiderata or however, whatever they are, they're considerations. So there's inappropriate language, but we all agree, I believe, that they are. I think my learned friend describes them as suitability, which is fine. But it's the CFO that has to apply 158 first.
Okay.
And it's only the recommendees that get through and are then substantively considered by the Commission, subject to the people who are overlooked, and that's dealt with in 155. So the first thing that we must do is the fire service, through the CFO, must notify all eligible officers. That's done, we say.
Sorry, where do you pick that?
I'm so sorry, 1551.
Right.
So they must notice. So that's done, we say, in respect of the first advertisement, because there's an advertisement in May 19, but it's not done in respect of the continuation of Mr. Lane's appointment in January 2020. He just stays in post.
And what's the consequence of that?
Well, other than a breach of 1551, I think the Court of Appeal's response to it is to say, well, you didn't meet the job specification.
So back to the job specification.
And if you didn't meet the job specification, then you can't complain about a breach of natural justice. So I suppose it's a sort of ex parte cotton type point. Or it's, again, or it's, it makes no difference because you weren't eligible. That's not a watertight argument for a reason I'll come to in a minute, and it concerns the word eligible. But that's the answer on the facts. You say, well, if we're entitled to rely on the job specification and we're entitled to think that the Commission will always apply the job specification, then he was never going to get home.
The job specification is devised not by the Commission at all. It's devised by the Fire Service in conjunction with the Ministry.
Correct.
And so therefore can take the decision completely out of the hands of the Commission, on your argument.
In a minimum, and it can, yes.
Totally.
Yes. Subject to the protections in 155, which is for persons who are overlooked, which is where Mr. Ramsaran makes a valid argument. So that's 151.
There's always a live issue as to what 6 years senior managerial meant.
I know. Well, it's a very complicated...
Is there any contemporaneous document at any stage, either from the Fire Service or from the Ministry or from the Commission, saying what they meant prior to the advertisement of May 2019?
I don't believe so, my lord, no. But what there is an established practice which we can infer from, well, not just infer, but calculate from the way in which the periods were readied in this case. Anyway, so, but I'll come to that point. But 1551, 1513, there's the 7-day period that must be allowed to elapse. We've dealt with that one already.
But here they did the wrong way around because they'd already sent the recommendation 2 months before. Is that right?
Sorry, my lord.
They'd already put in the recommendation, is that right?
The March one, but as I say, I think that's...
Before the appointment was,
yes.
Before the eligible fire officers were notified.
But the Commission's evidence, I think, clarifies, in effect, that the process starts with the advertisement in May, and then it's the 2 recommendations made after that.
Well, there was only 1 recommendation after that in January.
2, one in January, 1 in February. The one in February was
All
for
right.
the January 20 to June 20 vacancy that wasn't advertised. So there are 2 recommendations. I will come to all of this, I promise.
Okay.
I know it's confusing.
Well, they'd already made 1 recommendation, though, which had put Mr. Lane in place in March.
Well, no, we say that he was put in place in June following the... he was put in place, yes.
But following the recommendation in March. There'd been a recommendation in March.
There'd been a recommendation in March.
But without an advertisement, is that right? And without any of this process here.
The advertisement went out in May, exactly, and...
and there was no further recommendation till the following January.
Correct. But nonetheless, it would appear from the evidence, I'm constrained to accept that Mr. Lane was allowed to occupy the office and de facto, effectively, and that raised questions that the judge did make findings on that.
And when that recommendation in January was made, it didn't, as 1555 requires, advise the reasons why other more senior was passed over. We said there was no one, do you?
Yes, exactly, there was no one. But my lord, your lordship's right, because if you don't advertise, then obviously none of 155 is complied with, because you don't advertise the post, and therefore there's no getting away from that. The answer to it is either makes no difference because of the job specification, or that's not a good enough answer. But that's a very, very short submission, and all of that. Quite a lot of my time, I suspect, this afternoon is just going to be taken up trying to deal with the legal points and make sure that we are ad idem, as it were, in terms of the framework and how it applies.
All right. Well, that may be a convenient moment.
Thank you.
For us to rise. We'll resume at 2, and you have until 3:45, I think.
Thank you.